Sahaj Vidhi www.sahajvidhi.in Question 1. Under what circumstances can the appropriate government commute the sentence of death and life imprisonment for any other punishment? Discuss model answer. The power to commute sentences, including death and life imprisonment, is a significant executive prerogative in India, rooted in both constitutional provisions and statutory law. Commutation refers to the substitution of a lesser punishment for a greater one. The appropriate government, either the central or state government, depending on the nature of the offence, can exercise this power under specific circumstances. Constitutional basis. Article 72 grants the President of India the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence, especially in cases of death sentences or sentences by court-martial. Article 161 grants similar powers to the governor of a state in respect of offences against any law relating to a matter to which the executive power of the state extends. Statutory basis. Code of Criminal Procedure, 1973, CRPC sections 432, 433, and 433A specifically deal with the powers of the appropriate government to suspend, remit, or commute sentences. Section 432. Power to suspend or remit sentences allows the appropriate government to suspend the execution of a sentence or remit the whole or any part of the punishment to which a person has been sentenced, with or without conditions. Section 433, power to commute sentences, equals this section directly addresses commutation. A sentence of death may be commuted for any other punishment provided by the Indian Penal Code, IPC. A sentence of imprisonment for life may be commuted for imprisonment for a term not exceeding 14 years or for fine. A sentence of rigorous imprisonment may be commuted for simple imprisonment for any term to which that person might have been sentenced, or for fine. A sentence of simple imprisonment may be commuted for fine. Section 433A, restriction on powers of remission or commutation in certain cases. This crucial section stipulates that where a sentence of imprisonment for life is imposed on conviction of an offence for which death is one of the punishments provided by law, or where a sentence of death imposed on a person has been commuted to one of imprisonment for life, such person shall not be released from prison unless he has served at least 14 of imprisonment, 3 years. Circumstances for commutation. While the CRPC grants the power, it does not explicitly list the circumstances under which commutation can be exercised. However, judicial pronouncements and established practices indicate several factors that the appropriate government typically considers. 1. Humanitarian grounds. This is a primary consideration. Factors such as the advanced age of the convict, severe illness, physical or mental, terminal disease, or physical disability that makes continued imprisonment unduly harsh or execution of sentence impossible, can lead to commutation. 2. Social and economic background. The impact of the sentence on the convict's family, especially dependents, and their overall social and economic circumstances may be considered. 3. Delay in execution. In cases of death sentences, an inordinate and unexplained delay in the execution of the sentence, often due to prolonged litigation or administrative delays, has been recognized by the Supreme Court, E.G. Shatrighn Chauhan v. Union of India, as a ground for commuting the death sentence to life imprisonment. 4. New evidence or facts. If new evidence emerges or facts come to light after the conviction that were not available during the trial, and these facts might have altered the verdict or sentence, commutation may be considered. 5. Good conduct and rehabilitation. For life imprisonment, the convict's good conduct in prison, their efforts towards rehabilitation, and the possibility of their reintegration into society are often taken into account, especially when considering remission or premature release after serving a substantial period. 6. Recommendations from authorities. Recommendations from the trial court, jail authorities, or other relevant bodies regarding the convict's behavior or specific circumstances can influence the decision. 7. Public policy and justice. Broader considerations of public policy, the evolving standards of justice, and the need for mercy in exceptional cases can also play a role. Judicial review. While the power of pardon and commutation is an executive power, it is not absolute. The Supreme Court, in cases like Kehar Singh v. Union of India, 1989, and Eparu Sudoka v. Gov. of AP, 2006, has held that this power is subject to limited judicial review. The review is not on the merits of the decision but on the grounds of arbitrary exercise, mala fide intent, or consideration of irrelevant factors, or non-consideration of relevant factors. In essence, the the appropriate government exercises this power as an act of grace and mercy, balancing the demands of justice with humanitarian considerations and the potential for rehabilitation within the framework of constitutional and statutory provisions. Please visit our website www.sahajvidhi.in for more content.